Good evening, friends. I appreciate the effort and initiative taken by AILU Ernakulam District Court Unit for organizing this webinar. Thank you so much, Advocate Dinesh Mathew sir, for considering me as the speaker. In 2015, the 253rd Law Commission recommended significant changes to the Indian judicial system to change the impression of Indian courts, to attract more international investments, to bring ease of doing business, and to extend fair and speedy disposal to the commercial litigations. These recommendations made significant changes to the Indian judicial system. The NCLT and NCLTs were formed by the amendment of the Companies Act, Insolvency and Bankruptcy Code, amendment to the Arbitration Act, and most importantly, topic of the day, the Commercial Courts Act. Everything is there in the name itself. Commercial Courts Act. It's an act established for the constitution of the commercial courts for resolving the commercial disputes. It's a small act consisting of just 23 sections, divided into 8 chapters. If you ask me regarding a particular section in a particular statute, I will ask you to go through the entire chapter, because each chapter is having its own scheme and spirit. So try to understand the scheme and spirit of each and every chapter, then to go deeply into those particular sections. Here also, I will take you chapter by chapter. Chapter 1 is preliminary, basically the definitions. Commercial disputes are defined in 2(1)(c). 21 items are listed as commercial dispute in the Act. Those are disputes in the ordinary course of business of merchants, traders, bankers, financiers, export and import, maritime, admiralty, carriage of goods, contracts, infrastructure developments, franchisee, distribution, shareholding agreement, the intellectual property rights, etc. Definition number 2, subclause 1(7). Doubts may arise in the mind of all lawyers. It's regarding the immovable property. If the agreement is entered into with respect to an immovable property exclusively for the trade and commerce purpose, those disputes also will come under the definition of the commercial dispute as per the Act. This was considered by the Delhi High Court in a number of cases. The Jagmohan Burns case, Monica Arora, Ambulan Sarabhai Enterprises Limited. In these 3 cases, the Delhi High Court held that if the agreement is entered into with respect to an immovable property exclusively for commercial purpose, it is a commercial dispute and the commercial courts have to consider this. Courts also observed that you have to read the explanation along with this listed 21 items. Explanation 2 says, if the state is a contracting party, then also the dispute with the state is a commercial dispute as per the Act. This is a great opportunity for us, the trial court lawyers, to explore the possibility. Now, by this legislation, The legislature is trying to channelize the 226 jurisdiction to the commercial courts. So, the trial court lawyers act fairly and speedily. You should show the fairness to the litigation, to the legislation, to the court, to the opposite party, to the opposite lawyer, and move speedily. This is an area which we can explore in the coming days. That's all about chapter number 1. Let us move on to chapter number 2. Chapter number 2 is regarding constitution of the courts and its jurisdiction. For the purpose of the Commercial Courts Act, the states in India are divided into 2. The high courts of 5 states are having the presidency courts. That means those high courts are having the ordinary original civil court jurisdiction. Those are high courts of Delhi, Calcutta, Chennai, Mumbai and Himachal. The High Court of Kerala is not having any such ordinary original civil court jurisdiction. So, as per the statute, only 2 courts are established in Kerala as well as other states. The Commercial Court as well as the Commercial Appellate Court. The principal sub-court is the Commercial Court and the District Court is the Commercial Appellate Court. Regarding other 5 states, in the High Court, Commercial Division and Commercial Appellate Division are courts of fault. Now coming to the jurisdiction, in Kerala, the minimum valuation for a commercial suit is fixed as rupees 3 lakh. So any commercial dispute having a valuation of 3 lakh and more shall be filed only in the commercial court. Now moving on to section 8, it's a bar. No civil revision petition is maintainable against any order in an interlocutory application or regarding jurisdiction of the court. What you can do? You can only wait for the final judgment. If the final judgment is against you, you can file an appeal. In the said appeal memorandum, you can also raise grounds challenging the interlocutory orders and orders on jurisdiction. Section 9 is omitted from the statute as per the Amendment Act 2018. What is Section 9? In a commercial dispute pending before the civil court where the valuation is less than 3 lakhs, defendant filed a counterclaim for 3 lakh or more. Such suits shall be transferred to the commercial court as per Section 9. Now Section 9 is omitted. That means in a suit pending before the municipal court, a commercial dispute wherein the valuation is less than 3 lakh and the defendant raised a counterclaim for more 3 lakh or more, it need not be referred or it shall not be referred to a commercial court. Moving on to Section 10, it's all regarding arbitration. The proceedings before the arbitrator is unaffected. It's the same. But the applications and appeals under Section 7, 72, 34 and 37 shall be filed before the commercial court. Now Section 11, that is also a bar of jurisdiction of the commercial court. The commercial court shall not try any suit or petition which has specifically barred the jurisdiction of a civil court impliedly or expressly under a special statute. I can give you an example. The passing of infringement of right under the Patent, Trademark and Design Act, that is specifically given to the district court, for which the commercial court is not having any jurisdiction. But when it comes to the damage part, it's money suit. You have to approach the commercial court. Rent control matters. Suppose a movable property is exclusively given for commercial purpose under an agreement. The eviction jurisdiction is specifically given to rent control courts, for which the commercial court is not having any jurisdiction. The eviction part. Chapter 2 over. Let us move on to chapter 3. Chapter 3 is regarding valuation of a suit. All of us know how to value a suit. Recovery of money suit, it's the principal amount plus interest. Movables, we know how to value. Immovable property, the market value has to be assessed as per the provisions of the Court Fees and Suit Valuation Act. Intangible rights. A right, a freedom is given to the plaintiff for valuing the intangible rights. That's all about valuation. There is yet another bar under this chapter. No civil revision petition and appeals are maintainable against an order holding that the commercial court has jurisdiction. This chapter is regarding valuation. So this bar of civil revision petitions and appeal is with respect to the specified value part, the specified value, pecuniary jurisdiction of the commercial courts. Chapter 3 over. Let us move on to newly added chapter 3A, the pre-institution mediation and settlement. This is really beneficial for the litigants. You are initiating litigation to settle. Earlier, you initiated litigation to litigate. This is a wonderful opportunity to the litigants. A platform is created for settlement. An authority is formed as per the rules. Trained mediators are there, and this platform will help the litigants to settle their commercial dispute before going to the court. Pre-institution mediation is mandatory in all suits except cases in which urgent interim reliefs are necessary. Urgent interim reliefs means the attachment before judgment, interim prohibitory injunction, etc. Such suits, parties can directly approach the commercial court and satisfy the court that as urgent interim reliefs are required, mediation is not mandatory in that particular case. All other matters, first you have to move to the authority concerned by filing an application in the prescribed form by paying 1,000 rupees as fees. You can send the application, you can directly file it, or you can email the application to the authority. Authority will call upon the other side. Thereafter, it will be referred to the trained mediators. The total fees for the mediator shared by both parties is 15,000. That is the minimum. It will go up as per the valuation, go up. So, after exhausting this pre-institution mediation process only, you can approach the civil court by a suit. It is two separate process. The period fixed for completing the mediation is 3 months. With the consent of the parties, it can be extended for 2 more months. The Act says the mediation period, or it was considered by the authority and the mediator, that period is exempted from the mediation under the Limitation Act. This is a debatable point whether the period fixed under the Limitation Act can be extended by the provisions of a statute. In my opinion, both are central statute. Limitation Act and the Commercial Courts Act are central statute. And in my personal opinion, the period can be extended. There is nothing wrong. If the matter is settled before the mediator, an agreement in the prescribed form has to be entered into between the parties, signed by the mediator and parties, and you can execute it as an arbitral award. This is really beneficial for the parties. Now, moving on to next chapter, chapter 4, appeals. Appeals from order and judgment to the Commercial Appellate Court within a period of 60 days. So, the appeal from judgment and appeal, that is CMA from orders, shall be filed before the Commercial Appellate Court within a period of 60 days. The Act only prescribes one appeal. There is no second appeal, there is only one appeal. I am not forgetting the constitutional powers of the High Court as well as Supreme Court. With respect to the earlier matters also, even if there is any bar for appeals or civil revision petitions, the constitutional powers of the High Court as well as Supreme Court is there. That is my personal opinion. So, Commercial Courts Act provides only one appeal, and that has to be filed within a period of 60 days to the Commercial Appellate Court. Time limit is also prescribed for disposing the appeal. 6 months period. The Appellate Court shall take all endeavour to dispose of the appeal within a period of 6 months. All commercial disputes, all commercial suits and applications of the specified value pending before the other civil courts shall be transferred to the Commercial Court. So, the suits pending before the commercial suit of the specified value pending before the municipal court, sub-court, shall be transferred to the Commercial Court of having the jurisdiction. There is one exception, that is, if the evidence of the party is over, counsels argued the matter and it is reserved for judgment, such suits are exempted from transferring to the Commercial Court. After the transfer of the suit to the Commercial Court will renumber it, and after the receipt of the summons by the defendant, Commercial Court can decide the time for filing the written statement irrespective of the period granted by the civil court. Suppose in a civil suit, that is a commercial dispute of the specified value which was pending before the sub-court, The defendant got 90 days time for filing return statement. He has not filed it. In the meanwhile, it was transferred to the commercial court. Then also, the commercial court can decide the time for filing the return statement. At that time, definitely the commercial court will consider the period obtained by the defendant for filing the return statement in the civil court. This was considered by the Bombay High Court in Reliance General Insurance Company's case. And the court held that even after getting 90 days time in the civil court, the commercial court can decide the time for filing the return statement. Now, section 15 says suits and applications. What are these applications? Whether execution petition will come under applications. Whether EPs with respect to the commercial disputes of the specified value shall be transferred to the commercial court. It's a debatable point. Execution petition, even though we are referring it as an execution petition, Order 21 Rule 10 says application for execution. It's an application. What is referred in section 15 is suits and applications. So execution petition is also an application. Let us, our court, consider this issue and pass judgments on it. Let us wait for some time. It's a debatable point. That's all regarding chapter 5. Let us move on to chapter 6. Amendments to the CPC. It's not actually amendments to the CPC. CPC is made applicable to the Commercial Courts Act with amendments, with modifications. There are a lot of amendments, but I am referring only with respect to 7 important amendments. One is cost, second is filing of the plaint, third is return statement, fourth is timeline, fifth is summary judgment, sixth the case management hearing, and 7 the proof of hurt. Let us consider the first point, cost. Earlier, it was only expenses of the party, successful party, and his lawyer's fee. Now, it is not the expenses and lawyer's fee. Exemplary cost as penalty can also be imposed by the court. Earlier, only the successful party alone was entitled to this cost. Now, situation changed. Even the unsuccessful party is entitled to cost from the successful party. One example, in a commercial suit for recovery of 20 lakhs, plaintiff alleged that 20 lakhs is due from the defendant. Defendant filed a written statement stating that what is due is only 15 lakhs. After trial, court held that what is due is only 15 lakhs and the claim regarding 20 lakhs is false. So, the plaintiff is successful in getting a decree for 15 lakhs, but he incorporated false and frivolous contentions regarding 5 lakhs against the defendant. Even though defendant was not successful, the court can impose cost on the plaintiff for making false and frivolous contentions. There are various criteria to be considered by the court in imposing costs. Frivolous claims and counterclaims, unreasonable refusal to a reasonable settlement offer, So, how you conduct the case, how was your pleading, any false and frivolous contentions, whether you refuse to settle the matter reasonably. These are the points in which the court considered while imposing costs. Section 35A2 is omitted from the statute, that is regarding compensatory cost. The maximum compensatory cost which a civil court can impose was rupees 3,000 as the upper limit, or as that particular section is omitted for the purpose of the commercial litigations. Now, any amount can be imposed by the commercial courts. One more cost, exemplary cost. At any stage of the litigation for non-compliance of the directions of or orders of the commercial court. So, three kinds of cost. One, the cost which passed along with the judgment. Second, compensatory cost. Third, exemplary cost which can be passed by the court, for at any stage for the non-compliance of the orders and directions of the commercial court. So we should be very careful in conducting the case, taking up the contentions, complying with the directions, etc. Otherwise, there is every chance for imposing costs, compensatory cost and exemplary cost on your party. So, the first portion of the amendment, cost over. Let us move on to the filing of the plaint. Regarding plaint, the plaintiff need to state the facts in detail. It should be specific and the opposite party shall understand what exactly your contention is. It should be specific and detailed. The plaintiff shall also produce all documents in his power, possession and custody along with the plaint. That means those documents can be supportive or adverse to your case. Even though it is adverse to your case, then also the plaintiff is liable to produce all documents in his power and possession along with the plaint. The list of documents shall be in detail. Who executed the document, in favor of whom, the date of the document, whether you have produced the original certified copy or the photocopy, etc. shall be stated in detail in the witness list. If some of the document is not in your possession and that is in the possession of other party, you shall specifically state in the plaint that such and such document is in the possession of such and such party, and shall also seek the leave of the court directing that particular party to produce that particular document before the court. Suppose there is a litigation between two corporates. There are 2000 email communication between them. Whether the plaintiff need to produce all these 2000 emails before the court? No. In my opinion, all relevant documents, all relevant emails shall be produced by the plaintiff. Emails which are not relevant according to the plaintiff can be avoided. That's my personal opinion. Thereafter, you cannot say that this email was with me. I thought it was irrelevant, but later on I found that it's relevant. So I may be permitted to produce those documents, or that may be accepted. Such application is not maintainable. Delhi High Court considered such an application. In D&H India case, the Delhi High Court hold that particular case also, the document which are in the possession of the plaintiff was not, some documents was not produced by the plaintiff. Later on, he filed an application to accept the documents, and the court dismissed the application, holding that the reason stated in the application is not convincing. So, the plaintiff shall produce all documents, relevant documents in his power and possession, along with the plaintiff. Now, details of the interest shall be specifically stated in the body of the plaintiff. As per which statute you are claiming interest, or which contract, which letter you are claiming the interest, what is the rate, if there is rate difference, what is the reason, and what is the total amount due as interest, etc. You need to specifically state in the plaintiff. And one more difference is, we used to file an affidavit in support of the plaintiff as part of the verification. Now, a structured affidavit as statement of truth need to be filed along with the plaintiff. The format is given as Appendix 1. So, in the format, you need to file an affidavit. There are two formats. First format is for the individual plaintiff, and second format is for the corporate's representative capacity, corporate's partnership, trust, etc. Now, amendment. Whether a commercial suit can be amended. If the reason stated in the amendment application is convincing, such amendment applications are maintainable. This was considered by the Delhi High Court in Jasper Infotech Private Limited case. There, the amendment application was allowed for amending the valuation. So, the plaintiff over. Let us move on to return statement. After the receipt of the summons from the commercial court, the defendant will get a maximum period of 120 days for filing return statement. Is it extendable? No, it is not extendable. If you file an application for extending the period or accepting the return statement which is filed after this 120 days time, it's not maintainable. You have to file the return statement within 120 days. The maximum period for filing the return statement is 120 days. This was considered in SCG contracts case, in Deshraj's case by the Delhi High Court, and a number of other decisions are also there. All decision says it is not extendable under any circumstances. The defendant has to file the return statement within 120 days. In the return statement, you have to deny or admit the contentions raised by the plaintiff in the plaint specifically. The facts, law, valuation, and jurisdiction part of the plaint has to be denied specifically. If you fail to deny the facts, valuation and jurisdiction specifically, then it will be considered as admission. Regarding valuation, if you are disputing the valuation made in the plate, you have to say what exactly is the valuation, what are the reasons for disputing the valuation, etc. Regarding jurisdiction also, if you are disputing the jurisdiction, you have to specifically state in the written statement why you are disputing and which court is having the jurisdiction and what are the reasons. So, evasive denial will not work out in commercial court. You have to make in detail and specific, including the reasons. Production of the documents by the defendant is asked by the plaintiff. Along with the written statement, you have to produce the documents. If you are not in possession of any document, you have to specifically state in the written statement and shall seek the leave of the court for directions to produce those documents by those particular parties. The third part, written statement, is over. Let us move on to timelines. Next most important change made to the Commercial Codes Act is the fixing of the timelines. The filing of the written statement, the inspection of the documents, etc. Specific timelines are prescribed. A plan is set up for the ultimate disposal of the case. It starts from the date of service of the summons on the defendant. The defendant will get 120 days time for filing written statement and counterclaim. That is the first timeline. If counterclaim is there, the plaintiff will get an opportunity to file replication or counter written statement to the counterclaim. From that date, the next timeline starts. Along with the plain and the written statement, both parties produce their documents. So, next timeline is inspection of documents. The plaintiff shall inspect the documents produced by the defendants. The defendant shall inspect the documents produced by the plaintiff within a period of 30 days, which is extendable. You shall file an application stating convincing reasons. So, within 30 days, inspect the document produced by the other side. Now, third timeline. It's after the inspection of the documents by the plaintiff and defendant, they shall file a statement of admissions or denial of documents before the court. A detailed statement regarding admission and denial. You can admit a portion, you can admit completely, you can deny completely, but it should be specific. So you will get 15 days time for filing an statement of admission and denial with respect to the documents produced by the other side. This period is extendable. You can request the court orally for such extension. After the filing of the statement of denial or admission, within 4 weeks, the court shall post the case for first case management hearing. The case management hearing system is very important. I will take you later. But the next time prescribed by the statute is the hearing for the first case management hearing. On that day, the counsel appearing for both sides shall be present. If one of the counsel is not present, then also the court can proceed. Court can also request parties to be present in the court if there is a chance for settlement. So, within 4 weeks, the court shall fix a date for first case management hearing. Thereafter, within 6 months, the court shall close the arguments in the case. So, within this 6 months, the filing of the witness schedule, examination of the party, filing of the proof of date, cross-examination, etc., shall be completed, and the court shall close the arguments within 6 months. Thereafter, the court will get 90 days time for passing judgment. Why timelines? To avoid delay, a structured planned approach, and the parties will get clarity. Earlier, the court alone was controlling the timelines. Now, the lawyers as well as the parties will get an opportunity to fix the timelines, and each party will get an opportunity to get an idea when exactly his case will be over and the final judgment will be pronounced. Now let us move on to summary judgment, another important modification in the CPC. Summary judgment is known to us. Order 15 is there in the CPC, which is available to the plaintiff. Suppose in a commercial suit for money for 20 lakhs, the defendant admitted in the written statement that 15 lakh is really due from him, and regarding the claim of 20 lakhs is vexatious. There is an admission from the side of the defendant that rupees 15 lakhs is due from him. Then the plaintiff can file an application before the court for passing a summary judgment for the admitted amount of the defendant admitted in the written statement. What is the period for filing such an application? Application is mandatory. He shall state the reasons for passing such summary judgment, and the defendant will get an opportunity to reply, and after hearing both parties, the court shall pass a summary judgment, or court shall allow the application or reject the application. The period for passing the summary judgment is from the date of serving of notice summons on the defendant till the framing of the issue. After the framing of the issue, the court shall not consider an application to pass summary judgment. This application can be filed by the plaintiff or by the defendant. The summary judgment will be passed on the basis of the admission made in the written statement, and there is a statement of denial or admission of filed by both parties regarding the documents produced by the other side. So, by the filing of the statement of admission or denial, the court as well as the parties will get idea regarding the merits of the case. So, if admission is there in the written statement or in the statement of admission and denial made by the parties, on the basis of such admissions, the plaintiff or defendant can file such applications. The summary judgment can be passed with respect to the plain claim, entire plain claim, or any portion thereof, on a particular question, or entire counterclaim, or a portion of the counterclaim. That's all regarding summary judgment. Let us move on to case management hearing. Case management hearing is included in a statute for the first time in India. This is internationally known. The courts in the other countries followed this case management hearing. That is, after the filing of the written statement, the court will call upon the lawyers on the either side and fix times for the disposal of the case. To my knowledge, only in one case in India, this case management hearing system was adopted. That is, in the Salem Bar Association case by the Supreme Court, a case management hearing system was adopted. Now, after the filing of the statement of admission and denial of documents by either side, within 4 weeks, the court shall fix a date for case management hearing. On that date, both the counsels from either side will be present, and dates till the disposal of the case will be fixed by the court. First date, framing of issues. Second, finalizing of the list of witnesses. So, before the finalizing of the list of witnesses, we have to file the witness schedule. The court can remove irrelevant witnesses from the list, and the list will be finalized. Then, date for filing of the proof of debt. Then, date for examination of the witnesses on day-to-day basis. It has to be done in day-to-day basis. Then, filing of the argument notes. Filing of the argument notes is mandatory. Thereafter, the date for oral argument and the duration for each counsels also will be fixed by the court. So, each and every posting till the final oral argument of the court's final argument of the case will be fixed by the court on the first case management hearing itself, and the case has to be proceeded with the timelines fixed in the first case management hearing. Let us move on to the last modifications to amendment made to CPC, that is proof of debt. Proof of debt shall be in the chronological sequence. The first event first, second event second. In paragraph wise, we have to narrate. What is to be stated in the proof of debt? Only the facts. The facts known to the plaintiff or facts which he believes to be correct alone need to be stated in the proof of debt, and the marking of the documents also. Actually, our proof of debt is a reproduction of the pleadings. Is it correct? Not. Suppose in the plain legal grounds are raised. If it is reproduced, same thing there will be in the proof of debt. So the opposite lawyer need to be cross-examine him on the law points which he may not be able to answer. So such legal grounds and facts which is not known to the plaintiff or facts which are not believed to be correct by him need to be removed from the proof of debt. Otherwise, the court will strike off those portions of the proof of debt or the entire proof of debt itself. So, while drafting the proof of debt, we need to include only the facts known to the plaintiff or the facts which he believes to be correct on the chronological sequence, paragraph by paragraph. That's it regarding the Commercial Codes Act. Friends, the Commercial Codes Act is at its infancy. It requires the nurturing of one judiciary, executive, and lawyers. The judiciary has to designate judicial officers having the commercial inclination. Executive has to provide right infrastructure. Do you think one commercial court in one district is sufficient? No. We require commercial courts in each commercial centers. Of course, the key player is the lawyer community. We can be the maker or breaker. Our efforts to dispose of the commercial litigations in a speedier and fairer manner will definitely encourage more and more commercial litigations. Thank you.